Hello. Many of you will know, I'm Nicola. I'm going to be talking to you first, and then Ruth is going to speak to you in a little while with a general case law update at the end. I'm going to be talking to you on a couple of hot topics at the moment: presumption of parental involvement and then covert recordings. And as I said, Ruth is going to follow up with a case law update at the end. Our slides, I hope, are going to be fairly detailed, and I am quite conscious of the time, so I'm going to try and gallop through them so that we don't end up taking up too much of your evenings. Starting first with then presumption of parental involvement. I'm sure many of you know all the background to this. Suffice it to say that we had a report that came out at the end of last month, and the limitations make for quite interesting reading. I think it's really important to read the report in the context of these limitations because they, in my opinion, are quite significant. The first is that there was issues with access and the quality of the data the report was based on. The report acknowledges that much of the evidence that was used was out of date, dated back to the harm panel in 2020 that recommended that this report was done. It wasn't possible to estimate how the presumption was being applied across all decisions or the role that it played in individual decisions, which to me seems pretty fundamental. And the reporting process only had limited interaction with children, and the evidence mostly focused on adult views. It's really important, as I said, in my mind, to keep those limitations in mind when we go on to look at what they say the evidence suggested about how the courts applied the presumption. The first conclusion they drew is that the courts do not routinely reference the presumption, but that when they do, it is highlighted as one of several factors. That the data is incomplete, does not account for whether or not the presumption was factored into early decisions or orders made by consent. In terms of contact, the evidence suggested that direct contact was the most likely outcome, even where domestic abuse or harm was involved, that there was some evidence contact was pursued in cases with high-risk indicators, and that the court's approach could result in minimisation of domestic abuse, especially where abuse was considered less serious or historic. There was evidence that parental involvement was promoted at every stage of proceedings, that the courts took a no stone unturned approach, and that there was a positive duty on judges to promote contact by, for example, the European Convention on Human Rights. There was little evidence about what happened after proceedings. The report considers the impact on child welfare, and that's split out into different types of cases. Firstly, those with no risk of harm. The evidence focused primarily on the involvement of non-resident fathers and the difference between sole and shared care cases. No surprise, the involvement of both parents was seen as a positive thing for child welfare, and again, no surprise, the involvement of fathers was a positive thing. In terms of sole versus shared care situations, a lot of the studies didn't account for family dynamics and the experiences of children, and when there was a control for such things, the welfare outcomes between the two different scenarios disappeared. It's interesting, these very interesting outcomes to note, but again, I take you back to all the limitations in the methodology of this reporting and the absence of the voice of children in those conclusions. In no or limited contact cases, no surprise that the involvement of a parent who was a risk or who had harmed a child might not advance the welfare of that child. But the evidence suggested that the courts were ordering contact between children and those parents, which unsurprisingly may have lifelong negative implications for them. The conclusion is based on the high number of contact orders, direct contact orders, and the evidence that sometimes courts ordered contact in cases with high-risk indicators. And there's little evidence of the impact of limited or indirect contact or no contact with children. So in my book, the work in this area is incomplete. The report also looked at the involvement of children, and all will recognise something in the description of how children are involved or not, as the case may be. Their views are not always considered. If they are considered, it's often late in the process. And there seems to be a selective approach to listening with a preference for either older children or those in favour of parental involvement. Again, I take you back to those limitations. The voice of the child is missing in these conclusions that's being drawn. Most of the conclusions that I've put on this slide, I've already spoken to you about. There are a couple that it's worth mentioning. The central conclusion being that the assumptions, including the presumption, could drive decision-making and lose focus of individual children, and that, interestingly, there's a recognition that family practitioners try to keep child welfare central, but the system and decisions leave children at risk of harm. So for once, a positive vote for lawyers, but laying the blame squarely at the feet of both the system and the courts for following it, which again I find to be an interesting approach, because who writes the statute and creates the system? I'm sure many of you will have seen the press release back in October. The government's intending to remove the presumption. And I wondered when preparing this presentation how much there was really to say on this subject, because the honest position is we don't know what's coming next. They've said they're going to repeal it, but what does that actually mean? But actually I found when I was reminding myself of the contents of this, reading it in detail, that I actually had quite a lot of thoughts on this subject. The methodology I found problematic, and the more I read it, the more I felt that there were key pieces missing. There's no comment on the role of the local authority or CAFCAS. And I'm thinking here of the guidelines that we know CAFCAS have been told to put in place. It's not considered the question of evidence and truth within the proceedings, and that is a difficult subject in the context of domestic abuse, but it's the reality that the court's built on the question of evidence. And I shall name no names, but I remember hearing one of our Guildford judges say, people don't walk in with a sticker on their forehead saying they're telling the truth, and the courts have to take that into account. There's also an absence of any consideration of the interplay of the difficulties with the system. Decisions have to be made with delay in mind. Parties often want to avoid either delay or cost or various procedures, fact findings, for example, and there's a real lack of resources, and as I mentioned, costs too. Yet, with all that in mind, there's lots to recognise in the conclusions that are drawn. Clients are regularly told that domestic abuse is not serious enough, that it was too long ago, or that it's just not relevant. Clients are also often told that that contact's going to be the reality, and they've got to come to terms with that. Indirect contact orders and no contact orders are rare. They do occur, and there are lots of pro-contact judges. I think there's more work here to be done, and I think it's a question of watch this space and see what comes next. I ask myself, is removing the presumption is a positive thing? Children should have relationships, but domestic abuse should be properly recognised. Does it really change anything? These are all questions we don't yet know the answer to, and we're going to have to wait and see as to what comes next. I have a good feeling that this is going to be the subject of future talks, but we're going to have to grapple with whatever it is that comes next. Next subject is covert recordings. Again, I've set out the background to how we've ended up where we are. I'm sure many of you will be acquainted with the report that came out in May. That report, again, comes with a whole slide setting out some warnings that go with it. The first thing to say is that the report is not a guide to how to have covert recordings omitted. The second thing is, of course, all clients need to be told that there's an absolute prohibition on recording court proceedings. The implications, though, are often far more wide-ranging than a lot of clients appreciate, and I've set a lot of those out on the slide, some of them being fairly obvious: the impact on welfare, the impact on relationships between people who are co-parenting, between a parent and child, and it's clear too that those recordings may have an impact on proceedings. Will it impact on the quality of evidence because one party knew they were being recorded? Will it impact on the basis of, or will it undermine the basis of an assessment because that person knew they were being recorded? Is there a relevance to the fact that the recordings have happened rather than the content? And, for example, should the child be either represented or give evidence about the content of the recording? But clients don't often think that there are even wider consequences than that. There could be an impact on criminal proceedings if the person being recorded is a witness who is essentially being questioned by the person taking the video. There are human rights and data protection considerations. And we also have to think about the implications of the recording. Will there need to be injunctive proceedings? Will there need to be criminal investigations? It's potential that they could be sued within the criminal arena. And of course, there are cost implications as well. So these are all things that the clients need to be warned about when the dreaded word recording is uttered. The covert recordings fall generally into three categories, those being professionals, family members, really that refers to the other party, the other parent, and children. I've summarised in the next few slides some case law that is useful for each of those arenas. The first is the professionals, and these cases concerned the recording of a session with an assessment with a clinical psychologist, another with a foster carer. And in Re-B, the President recognised that there have been shocking examples of professional malpractice established because of covert recordings. So in my assessment, there are slightly more positive treatment within the professional arena of covert recordings than in the other two. The advice from CAFCAS to their practitioners is that there's no reason parties should not record. Best advice, if you're asked this by clients, is full disclosure. This goes from being a covert to an overt recording. And the CAFCAS officer should be noting that in the report so that that is obvious both to the court and to the other side. It may be open to them to seek disclosure of that in the appropriate circumstances. The CAFCAS officers also have been advised in the appropriate circumstances to seek directions if they're concerned about how that recording is going to be used. In terms of materials offered to CAFCAS, the policy is not to view it unless it is admitted into evidence by the court, and that is the approach that is recommended to other professionals as well. In relation to family members, primarily the other parent, again, a number of examples on the slides. These are essentially parents recording each other, and the case law here fits with my own experience that it never shows what they say it does. And the fact of the recording is often more telling than the contents of it. And self-defeating is a common description that occurs in much of the case law. Recordings of children, these are essentially cases where the parents are trying to establish the child's wishes. And we have the warning in M&F that reminds us that covert recordings of a child almost always likely to be wrong. So best practice, if you are offered recordings, caution essentially. Before listening, viewing, you need to establish a bit more about it, clarify the purpose, take your own advice, and obviously if they're offered within proceedings, that's a case management decision for the court as to what role they're going to play. If an application is to follow, then C2 at the earliest opportunity, and that earliest opportunity is emphasised because we don't want to take the case off on a tangential satellite litigation that could be both time-consuming and costly. The important thing is to set out the nature of the recording, the context, whether it's been edited in dates and times, the method of recording, why it was covert, and the relevance of the contents to the issues in the proceedings. The usual way, the court will then either list it at a forthcoming hearing or list a further application, a further hearing, and it will then follow the path that we're all familiar with for an application. In terms of then what happens once it's in the court arena, there's a lot of detail in part 4 of the report, and my recommendation is to read that in full if you haven't already done so. There's a helpful summary in Appendix 1 at the end of the report. The key is relevance and probity. Taken at its highest, is the recording or recordings, are they relevant to the issues that are before the court? Even if the contents aren't found to be relevant, it's a warning to us all that the fact of those recordings may be used then by the other side. So there's a lot to be cautious about with recordings, but that is a primary one in my view. The court's going to be thinking about hearsay, the overriding objective, its case management powers, whether the child was being assessed or examined, and a lot of that, there's a lot of detail involved in that, more than we've got time for this evening, but it is worth a deep dive if this comes up in one of your cases. In terms of directions, the court will be thinking about disclosure, transcripts, the details of the recording, so the scope, the context, how many there are, which of those are relevant, and we'll want to establish authenticity, any editing, probative value, and any welfare implications. And of course, there are then the natural consequences that flow of costs and the practical decisions that then have to follow about hearings and the like. One also needs to think about whether a Part 25 application is necessary, and I've set out at the bottom of that slide the factors that an expert might need to consider. A last word on the appendices, for once actually reasonably useful. Appendix 1 sets out, as I said, a summary of the principles. 2, some helpful template letters. 3 is about intimate images, which I haven't touched on. It doesn't feature heavily in the guidance, but is useful if that comes up in a case. And lastly, Appendix 4, which is a summary primarily aimed at litigants in person, but is actually quite a useful aid memoir and something that potentially could be shared with clients. That's a pretty quick gallop through those 2 topics, and I will now hand you over to Ruth for a case law update.
Okay, final part. We're nearly there, everybody. So I'm going to be doing a general case law update in regards to private law. The way I've chosen to take this, and please don't ask me why, because I regretted it by June, is to do a case per month of the year so far in review. There are so many words on your screen and in your handouts. I will not go through all of them. You can fight between whether you read this as bedtime reading or Kane's scoping report, as suggested. So starting with January then, so we have the case of ABC, child arrangements, where a final order was made at a dispute resolution appointment. On appeal, the question was the court wrong to make a final order at DRA? And the short answer is no, they weren't. It's within their powers to do so. Sorry, a note I should have started with probably is that the way I've tried to choose these cases is not necessarily choosing the biggest and most exciting cases, but perhaps the ones that come up most in our day-to-day practice. Certainly they have in mind, and I find those very useful, and hopefully you will as a takeaway as well. In respect then of February, we have Re-E, and this is a cost case. Probably not welcome news for lots of us that do lots of legal aid work, but the answer is yes. Costs can be awarded even if you're legally aided. There's a case also at the bottom there with C and S, which I do refer you to. There was an exceptional order in that case for mum to pay 50% of the father's costs due to her conduct during that case. The reason it was 50% is because there was a 30% reduction to reflect the successful outcome mum had in her case, and 20% due to her financial commitments in respect of supervision costs with the children. I rather enjoyed the comment that this is not to punish mum. Such award is not penal or punitive, as mum asserts, but it's to reflect that her conduct has been beyond what is reasonably acceptable. I'm sure the mother might have disagreed with that. X and Y, which I've referred to, I caution with Kane same morning that this was a lower court decision, so cannot officially be cited, but does raise some really useful points in respect of domestic abuse findings, Section 9114 orders, and also the need for Part 25 applications if you're seeking interrogation of phones, which I think we'll see more and more of. Moving on swiftly then to April. V and another. This is a useful case in my opinion, particularly if you're asking for contact whilst a fact finding is pending. In fact, I was able to quote the same today, as Nicola knows, but it's a case that, interestingly, contact was ordered whilst this was an appeal stage. So contact was happening overnight. despite the fact that a fact-finding hearing was upcoming. On appeal, it was said that this shouldn't have been the case, and whilst contact was pared back to not be overnight, it was not stopped entirely, despite the very serious allegations before it. So certainly a useful one for us when we're pending fact-finding. In respect of Re-A then, which occurred in May, there's a useful quote there at paragraph 13 of this, which helps us, it's reminders to practitioners and also to the court in respect of how to approach fact findings, the importance of case management and paring back the allegations wherever we can. And then Re-S in June there is an unusual case where an application for parental responsibility was refused. The reason being, you'll see at the very bottom there, is mainly because father's motive was found to be interfering with grandma's care of the child under a special guardianship order, which therefore the judge concluded that granting parental responsibility was likely to be detrimental to the child's welfare and may cause the child emotional harm. Swiftly on to July. This is a useful case. I've recently had an international relocation case, and this is helpful because what you often hear, I'm sure you've all come across it, is the plans aren't well thought out enough. There's not enough information here. In this case, that wasn't what was found at all. And the judge, you'll see at the bottom there's a quote, it was found that the judge was not wrong to grant the mother's application, notwithstanding that there was no finalised detail of the child arrangements, which again is a useful one for perhaps not the strongest set of proposals on relocation cases. August, committal proceedings, perhaps not that common in actuality, but I've certainly noticed lots of judges commenting at the moment, urging us to inform our solicitors to pursue committal proceedings if directions aren't followed. Of course, easier said than done. Quite often our clients don't really want to pursue committal. They simply want the order followed. But it is an interesting case where the father was committed to prison for 6 months due to various failings. I must say this is quite exceptional in that the paternal uncle actually abducted the child in Iran and threatened mum at gunpoint. So very exceptional. The child wasn't returned for some 19 months, etc. But in any event, a useful one to note for committal. And of course, as barristers, we like any opportunity to put a wig and gown on. So it's a good one. In Y&E in September, put simply, was the departure from CAFCAS recommendations allowed? Yes. We all know this, but a really nice, useful and recent case that on appeal as well, that dismissed all of the father's grounds from departing from the CAFCAS recommendations, reinforcing judicial discretion so long as there's adequate reasoning. It also notes the high threshold in challenging welfare decisions at an appeal stage, which is always useful, particularly when you've got a moaning client who might like to challenge the decision. Nearly there, October. So this again is a useful point in respect of costs. This was on an appeal point, and again, somewhat unusually, whilst mother wasn't successful on appeal in respect of some of the child arrangements decision and her costs in this case, it was held that father's refusal to a non-molestation order continuing despite and following serious findings of domestic abuse meant that he should be liable for at least some of the mother's costs for the Family Law Act hearing. He was ordered to pay £5,000 of the 13.5 roughly that was sought. And then finally for November, this is not case law as you'll see, so you might say I've chickened out, but this one was, I thought, very interesting. And it's as of the 7th of November, so very recently indeed, the enactment of section 49A of the Domestic Abuse Act has come in. I won't read out point 1, which basically says that point 2 needs to be followed. But this is essentially saying that if a member of the police force has reasonable grounds to believe that a child who resides in a police area may be a victim of domestic abuse, any relevant educational establishment is notified as soon as is reasonably practical, except in such circumstances as may be specified in regulations made by the Secretary of State. This, I think, will be very interesting. We will certainly, I have no doubt, have clients very unhappy about this, particularly the word may. They may believe that they are victims of domestic abuse, and this may cause issues moving forwards, as it's only very recent. That's yet to be seen. That concludes Guildford Chambers seminar evening. Sorry for whizzing through that. Thank you all so much for coming. If you have any questions at all, please do come and speak to us. We'll probably be over by the canapes. And please do enjoy a drink as well. Thank you very much.